Call the first case on this morning's docket. That is case number 104316, Stanley Bank v. Johnny R. Parish et al. You may proceed, counsel.
Thank you, Your Honors. Mr. Bueller. May it please the Court, Michael Millett, Your Honor, on behalf of Robert Bazine and Bazine Excavated Incorporated. Mr. Bazine appears in person as well as a representative of Bazine Excavated Incorporated. Your Honor, the District Court in this case made a couple of specific findings. One was that it believed that Robert Bazine had actual knowledge that there was a lien on the vehicle. As the Court knows, a motion for summary judgment, standard in looking at that is the light most favorable to the non-moving party. Mr. Bazine, in a deposition that was taken, stated numerous times that he had no idea if Stanley Bank had a lien on the vehicle. Stanley Bank relies on statements made by Mr. Bazine in that same deposition that states that he saw a registration noting Stanley Bank's lien on it well before he took possession of the vehicle. The information that Mr. Bazine had was essentially stale. He knew that at one point in time, based upon a registration that he had saw on Mr. Parish's desk, that there was a lien noted on there. However, whether that lien was still active and valid was unknown to Mr. Bazine. When he went to the Department of Revenue and he provided them with the paperwork to obtain titles for the sale to go for these vehicles at auction, he asked specifically, I thought there might have been a lien on one of these. He was told by the representative of the Kansas Department of Revenue, not anymore, and was provided with two clear titles for the vehicles. The only one that's at issue here is the GMC Yukon, which did not indicate any lien for Stanley Bank. The court even struggled with this and stated at one point, when somebody at the Kansas Department of Revenue, who is issuing the titles and appears to go look up the information in response to the question that there may have been a lien, and she says not anymore, isn't the reasonable inference that the court must draw at this point in time is whether or not he becomes an innocent third party. Clearly, whatever information or knowledge Mr. Bazine may have had prior to going to the Department of Revenue and obtaining the title, it doesn't matter anymore. At this point in time, once he's told that there's no longer a lien on the vehicle, once he's provided with clear title, a reasonable person would rely on that, and that's what his knowledge was at that point in time.
But what are you saying? His status is a innocent purchaser without knowledge?
I'm saying that the district court specifically found that he had knowledge, and I'm saying that a reasonable person wouldn't have had knowledge given the information that they were provided.
Is that what drives the wagon here? I mean, if he's just a competing creditor, can he close his eyes and not do the investigation, or does he get the benefit of misinformation? Doesn't he have to be an innocent purchaser without knowledge?
But whatever knowledge he had, just because at one point in time...
Okay, let's back up. Is he an innocent purchaser of this vehicle that he repossessed?
He would be an innocent purchaser, but I don't even think we have to get there. But yes, I think he is an innocent purchaser. I will discuss that. The Court of Appeals goes through 3 different factors to determine whether or not he's an innocent purchaser. But again, these are questions of fact. And when a motion for summary judgment, when you're trying to decide what the person's state of mind is and what knowledge they had, we generally don't make those determinations on a motion for summary judgment.
Sir, can you address what the Court of Appeals did was look at the code, look at the Uniform Commercial Code, which no one had done up to that point, and they basically said the bank had a perfected purchase money security interest. That's undisputed, I think.
Actually, no, it would be disputed because actually
Why would that be disputed?
Well, because the Court of Appeals did look at the UCC, and what you're actually supposed to look at is Article 8, Chapter 1, Section 35.
I'm sorry, why would that be?
8135 guides perfection of titles in this state. And when you look at 8135, when you have a purchase money security interest, which is what we had in this case, presumably, we don't even know that fact for sure, but it's presumed that it's a purchase money security interest because a notice of security interest was filed by the bank. So presumably they loaned the money for the purchase of the vehicle. Then they issued a notice of security interest to the Department of Revenue. That only temporarily perfects the interest in the vehicle. And that is discussed at length in the case of Henry Hicks. Once the application for title, and what that is because a person may not go right away and make application for title. Okay, so
well, we're getting off base here. What I'm talking to you about is, did the bank perfect their purchase money security interest?
They filed a notice of security interest,
right,
which would have been a temporary perfection.
And according to the code,
they then a request for registration and title was made, and they indicate that an e-title was then noted, and so their lien was noted.
And it was noted on the paper registration and receipt.
But then, when a title was issued...
Let's focus on right then, because under the statute, as the Court of Appeals said, that's when the bank's purchase money security interest was perfected. When that original, let me finish my question, when the original title was issued reflecting the purchase money security interest. What about the Court of Appeals' opinion is inaccurate?
No original, well, one, they focus on the UCC, and they should be focusing on 8-135.
8-135 applies to, the provisions of paragraphs 1 through 14 apply to certificates of title issued prior to January 1st, 2003. And we're talking about an electronic certificate of title here, as the Court of Appeals pointed out, right?
This is an electronic, we've now gone to electronic certificates of title, correct?
Yes.
Yeah. And so at that point in time, when the electronic...
Tell me about what the Court of Appeals said. This is a petition for review, and I don't hear you explaining to me why the Court of Appeals was wrong. In fact, you don't indicate that really in your petition.
The Court of Appeals was wrong in a variety of instances. One, the Court of Appeals made... again, they were arguing the UCC, for one. But also, when they... And I believe 8-130...
The Court of Appeals wasn't arguing. This was their opinion that they issued.
Correct. The Court of Appeals, in its opinion, when it references the UCC, it's 8-135 is my argument that I say that you look at, and that's what determines. And there's a temporary perfection and there's a permanent perfection. Are you correct? Did the bank have a perfected security interest in this vehicle for a time? Yes, but once a paper certificate of title was issued, that defeated their perfection and their security interest because we rely on paper certificates of title. There's all sorts of cases that talk about it doesn't matter if the state made an error. If that's the state's error, that's something the Stanley Bank could take up with the state. The fact of the matter is the paper certificate of title is now issued. And that's what most people rely on.
I don't want to know about what most people rely on. What in the code are you looking to suggest that once that the electronic title is reflected and it's properly perfected, which it was here, and it was reflected on the paper title, that somehow when the KDOR makes a mistake years down the road and issues a paper title, even though it's properly reflected on the certificate of title, electronic certificate of title, that somehow it's the bank's problem that they made that mistake.
It is. Henry Hicks says that very clearly.
And that was totally different in the sense that there was never a paper certificate of title and registration receipt, as there was here, issued perfecting the notice of security interest that was filed.
There was. I'm not sure that I would agree with it.
And the court. That is correct. And the court specifically said in that case, we're not talking about electronic certificates of title here.
There's also the cases of Henry Anderson, there's cases of Henry Geiser. There's multiple lines of cases that talk about, and you asked what, as far as the state issuing the title. First off, 8-135 says, no certificate of title shall be issued for a vehicle having any unreleased lien or encumbrance thereon. The state did that. It also...
Right, but what are you looking to? There's no question here that there was a mistaken paper certificate of title issued, although all the way through, the bank had perfected their security interest and the proper electronic certificate of title is in place. So given that, what are you looking to suggest that that subsequent error by the KDOR, given there was an error, given there's no fact issue that there was an error, somehow puts the bank's priority below your client?
Because at that point in time, in order to have perfection of a security interest in a vehicle, it must be reflected on the title. And it was not. The cases are replete with it.
It was reflected on the original receipt and the original registration, just as that statute you're pointing to requires.
But it wasn't at the end. So what happens? I
agree with that. But what are you pointing to suggest that because it wasn't at the end, somehow that becomes the bank's responsibility?
The cases, the statutes, the administrative regulations, 925124 says that no certificate of title, no printed certificate of title shall be issued unless, there's no lien or encumbrance on it. There's certain exceptions under 925128 under the Kansas Administrative.
A mistake was made. I don't think I'm not disputing that. I'm trying to get you to talk about whose responsibility in terms of priority that mistake is, and I don't see you doing that. And what the Court of Appeals opinion said was it's the bank's perfected purchase money security interest remains in place. And I just don't see anything addressing that here.
Again, I guess I can only rely on the cases that say once a certificate of title is issued at any stage, it doesn't matter. When you look at these cases, in the line of cases, certificates of title are issued at a variety of different stages, whether it's a refinance situation, whether it's when they do go and make application for registration and don't note it. I mean, in Hicks, the person under 135, they're supposed to tell the Department of Revenue that there's a lien on it. They didn't even bother to do that, which was raised by the district court in this case.
Right, on the original certificate of title, which is what the statute addresses.
But, they didn't do that. A title was still issued without anything on it. In Anderson, I think 2 titles were issued in an Entrust Bank case. And in those cases, both titles show nothing on there. Again, the average ordinary person relies on a regular paper certificate of title. That's how most transactions are done. No one has access to this e-lien site. That's only for lenders and dealers. Regular people can't get on and see if there's a lien on there. As far as trying to find out and do a title history thing, there's a specific form that the Department of Revenue has. It's TRDL 302. Well, that particular form, you still have to fall under certain categorizations in order to make the request. And so an ordinary average individual cannot go back and look and see whether or not there is a lien on a certificate of title other than what they're presented with. And no one, because this is an e-lien state, no one should get a paper certificate of title if there's an encumbrance on there because they're not issued. Only under certain very narrow exceptions that are noted in the Kansas Administrative Regulations 925128, and that's if like a foreign jurisdiction won't accept the e-title. And so in that circumstance, then the court can, or the Department of Revenue can issue a paper title. So once a person gets a paper title in this state, it's automatically assumed that there's no lien because we don't issue them if there's a lien.
Counsel, I think my colleague has exposed some potential obstacles to your argument. So let's talk about whether you might have a more successful avenue by focusing more on how the issuance of that paper title might have changed the status of your client as opposed to changing the status of the PMSI.
Okay.
I think you started there at the beginning of your argument, and my other colleague asked you whether he was an innocent purchaser. So it's your position, as I understand it, that the issuance of that paper title basically erased whatever knowledge he had of the prior lien. Is that correct?
That's correct, Your Honor.
Okay.
And thank you. And
is there anything else on that subject you'd like to share with us?
Sure. As far as an innocent third-party purchaser, Your Honor, the Court of Appeals identified three things: whether or not value was given, whether or not he had possession, and whether or not he had knowledge. Okay? All of these are question of facts right out of the gate. So, that have to be decided not on a motion for summary judgment, but once the facts bear this information out. As far as possession, there's oftentimes the confusion that Bazine Excavating Incorporated is Robert Bazine. Well, they're not. They're two separate individuals. One's an entity and one's an individual. Bazine Excavating Incorporated had the judgment against Mr. Parish for him embezzling against Bazine Excavating Incorporated. And they're the ones that attached the vehicle, and then at that point in time, then took the vehicle to a place to be stored and eventually sold. So Mr. Bazine, Robert Bazine, never had possession. Bazine Excavating Incorporated may have technically had some possession at one point in time before they took it to the place for storage and sale.
Could I have you address the Court of Appeals findings? That you just mentioned that there were these three findings, but the Court of Appeals specifically stated that those findings, they themselves said it's dicta. And in even addressing the innocent purchaser findings, they were discussing a statute that no one had raised, or the code, 849337 is what they were discussing, which has to do with when a certificate of title is issued by an out-of-state jurisdiction. And for whatever reason, the Court of Appeals added that in at the end of their discussion, but and recognized essentially within their own opinion that it was dicta. I would like for you to address how, outside of that provision, which clearly doesn't apply here, these facts related to him being an innocent purchaser pertain to the priority issue.
I think there's in Article 9, and I apologize, I didn't focus too much on Article 9. I think it's 84.9. I want to say 301, I believe, talks about people that take without knowledge and that in the ordinary course and so on. And so Mr. Bazine would fall under that categorization. But even getting to that, you got to remember these were claims for conversion. Okay, conversion is unauthorized assumption and exercise of the right of ownership over goods or chattel belonging to another. Okay, that other isn't Stanley Bank. This vehicle, the Yukon, didn't belong to Stanley Bank. Robert Bazine couldn't have converted the vehicle from Stanley Bank when it didn't belong to them. It belonged to Johnny Parish, not to them. They had a right maybe to the proceeds from a sale if they sold the vehicle, but they sure didn't have the right to the vehicle itself. And so the conversion in and of it there would fall, as well as the proceeds argument for the conversion. There's cases repeatedly that state that the conversion for proceeds is not, it cannot lie. Okay, you cannot have a conversion just for proceeds. You fall into a debtor-creditor relationship at that point in time, and that's what Bazine Excavating would have been to Stanley Bank, is just a debtor to Stanley Bank where they owed the money, and that's even proven by the March 19th letter sent by Stanley Bank where they request the proceeds, which even goes back again to the vehicle that they weren't awarded. The district court didn't award Stanley Bank the vehicle, awarded them the proceeds. And so, to say that Mr. Bazine converted the vehicle itself when Stanley Bank didn't have a right to it, and then to say that Bazine Excavating converted the proceeds when action for conversion will not lie for proceeds, I just think that clearly, in my opinion, that there's no question that the motions for summary judgment by Stanley Bank should have been denied, and technically the motion for summary judgment for Bazine Excavating should have been granted. And that's what I feel like we should have been talking about, is the motion for summary judgment by Bazine Excavating, because he had the right to rely on the title that was issued by the state. Erroneous or not, that is the issue that these banks should have taken up with the state. I know I've been way out of time for a while. I really appreciate all the questions and the time.
Well, I do want to follow up. I don't think that answered my question. My question was, is there anything in the code that you can point to that says an innocent purchaser, assuming an innocent purchaser, has priority over a properly perfected purchase money security interest?
And that's
what my question had to do with.
Because you were referring to cases that talk about it. And again, you have to go into the underlying, cause of action, and that's conversion. And I guess that's where I was getting at, is that the cause of action can't even stand in and of itself.
I'm not talking about the conversion. I'm talking about who has priority right now. I'm talking about what gives your client priority over a properly perfected security interest, and you look to the code to determine that. And
again,
I had pointed to the provision that you were discussing when you were talking about innocent purchasers, and that provision is what the Court of Appeals cited that doesn't apply, and they recognized it doesn't apply. So I was trying to see if there's anything else that, because we're talking about priority here. And so I was trying to find out if there was something else that would give an innocent purchaser some kind of priority, assuming, and I understand you dispute this, I guess, that it was a properly perfected purchase money security interest.
I don't dispute that it was properly perfected. It just wasn't continually properly perfected. They lost their perfection when it wasn't noted on the paper certificate of title that was issued to Mr. Brazine on September 19th of 2007. At that point in time, they lost their perfection.
So your position is the KDOR, mistakes that they make can overcome a properly perfected purchase money security interest.
Absolutely.
Okay.
And I think the cases indicate and bear that out.
Okay.
Yes.
Do we have any further questions of counsel? Thank you, counsel.
Thank you, Your Honors.
Counsel, before you begin your response, I'd like to ask the gentleman in the back row to please remove your cap. Thank you. And also, since I've already interrupted the flow of your argument, I'd like to announce we've had a group of people come in. Is there a teacher or an adult supervisor who could let us know who is in our audience?
Yes, this is fifth grade class, 2 fifth grade classes from Pontotoc.
Very good. Well, welcome to all of you. My apologies, counsel. Please proceed.
Not at all, Your Honor. R. Scott Beeler of Lathrop and Gage, representing Stanley Bank. Welcome to the folks from Tongi and Mr. Miller. I think that this case can be summed up by saying that the appellants here do not argue that their interests have any priority over the or under the statutes which govern priority. Instead, they are simply arguing that the actions of the appellants, and let's not forget it was the appellant who drove to the KDR with paperwork to attempt to convince someone to give him the free and clear paper title. He didn't ask for a copy of the existing title. He did not ask for or present any paperwork to explain to KDR how the existing title and the lien that was reflected on it and had been reflected on it for years had been released. Instead, he played along, and he went along with the mistake. And as a result of it, his argument is, through his own actions, in acquiring that paper title, he somehow magically and then legally acquired a clean title and erased a properly perfected purchase money security interest.
Counsel?
Yes, ma'am.
Isn't what he did when he arrived in Topeka to talk to the KDOR personnel a question of fact?
No.
Whether it should be characterized as him attempting to persuade them to provide a clean title rather than, as your opposing counsel characterized it, he said to them, I thought there was a lien on one of these? I mean, isn't what actually happened in that conversation a question of fact, not subject to summary judgment?
No,
Okay.
because
How come?
he admitted in his deposition cited in our brief to the appellate court over and over. I mean, I heard counsel's comment as to what he says he admitted to, but I'm happy to read from that testimony for this court because he was asked over and over about what he knew.
Before he got there,
Yes,
right.
which then
But according to counsel,
characterizes-
did he ever say what counsel said he said earlier? Did he ever say to the person who assisted him, I thought there was a lien on one of these vehicles?
He so testified
Okay.
that he did say that.
Okay.
But it is, what I'm saying is what he carried with him in his mind, what he knew, maybe better said.
Yeah, that's the problem.
The
What
only-
he
well,
knew and what he
but
thought
what
he got
had-
convinced of.
I don't mean to interrupt.
No, that's okay.
What he admits he knew When I said, when did you first become aware that Stanley Bank had a lien on the GMC Yukon? That's in the Record on Appeal, Volume 1, page 157. His answer, well, I saw a copy of the registration on it.
Right. I'm not saying that that's disputed, because I don't think it is. I'm saying the characterization of his behavior once he arrived. I think your initial point as you arose from council table was that what he showed up to do here in Topeka with the Department of Revenue folks had nothing to do with just, asking a question and seeing what the status was. It had everything to do with him attempting to lay the groundwork for what he ultimately did. That was how you characterized it. I'm just saying the characterization. If your argument's dependent on the characterization, the characterization is subject to dispute, I think.
My argument is based upon his admission as to the knowledge that he carried.
Okay.
And he did that over and over.
It was just too late by the time he got to Topeka.
Correct.
That's your argument.
How he characterized it to the woman in Topeka.
That's what I was trying to get at, because I think once you get into characterization, you lose summary judgment.
No question about that. It becomes a fact dispute. But here, that is not the case. There is no fact dispute. His knowledge was he never heard anything other than that there was a lien. Not only heard, but saw.
But did he testify that he knew that your client's lien had not been released? I mean, the fact that he saw that there was a purchase money lien in the beginning doesn't mean that he knew it continued to be valid and in force when he got the paper title.
I would, to properly characterize what he said, he did it in reverse. I asked the question, once he said, I saw it, I'm aware of it, I said, have you ever seen anything to suggest that Stanley Bank ever released its lien?
Except for the fact that he got a paper title that didn't have a lien on it from the KDR.
I'm aware of that, but in the deposition, I'm asking him, again, before he goes to Topeka, what is your knowledge base? And he said, no.
But what I'm asking is, don't you have to show that he not only had knowledge that there was a lien at some time, but also that he had knowledge that it had not been released? When he's handed a document that purports to show that the lien has been released, don't you have to show he should have had independent knowledge to know that was incorrect?
No, I don't believe so, sir, at all. Again, once Stanley Bank had done everything it could possibly do in the sense of perfecting its security interest.
We're not talking about what you're doing from your side. We're talking about knowledge. That's you stood up and said what he knows or what he didn't know. And what I'm saying is, what evidence is there that he knew that the lien had not been released as he says that he was advised by KDR?
Because the public record said it had not been released.
And that was the electronic.
Absolutely, which is the way that this title, and any title, I might add, that bears a security interest reference on it is in Kansas.
And relying on that, I want to return to something else your opposing counsel said about ordinary people not having access to that. Do you disagree with that?
Absolutely.
Okay. That puzzled me when it was said.
I guess I'm confused here again. The Court of Appeals made it very clear that the innocent purchaser provision of the code, which is what no one seems to want to talk about, which establishes priority interests, applies, yes, if, number one, there was a purchase without knowledge of the security interest, which is what we're talking about here. But even assuming that there was no knowledge, even assuming the facts, there's other requirements, and that is it has to be for value. That's not disputed. It's primarily for the buyer's personal, family, or household purpose. We're not talking about that. But key to that is, for that innocent purchaser provision, for that purchaser to have priority is, it has to be before the filing of a financing statement covering the goods. We don't have that here. That's what the Court of Appeals said. I'm confused as to why we're talking about the first element, which is whether it was or was not without knowledge, which appears to be a disputed fact question that doesn't make any difference if the bank had a properly perfected purchase money security interest, as the Court of Appeals said.
I, of course, agree. I was simply trying to address
Okay.
argument that had been made here, and I do not believe that there is a fact argument with regard to the knowledge. The question is, and pardon me, Justice, but you said it yourself, that there's no dispute there was an error made.
Right.
Stanley Bank was properly perfected. And again, as is stated in the briefs, it's been shown all the way through the course of the Court of Appeals matter that their electronic lien still remains on the title. And I can advise the court that if they walk back in chambers and got on your computer, you can check it. I mean, the point is, there is a properly perfected lien. And as I started to say, and I'm afraid by some of the phrasing I used, I got off in the wrong direction, but the argument is simply from their standpoint that they agree it's properly perfected. They completely agree. They're simply saying that at the moment of an error, despite what knowledge he may have had carrying in, that it erased the properly perfected lien. And there is no provision in the UCC or otherwise, Chapter 8 or Chapter 84, that speaks to a properly perfected security interest being extinguished with an innocent purchaser sale. That simply is not the case. And then I do think it's imperative that we talk about Hicks, because counsel is relying so heavily on that case. And Hicks certainly does not. In fact, I would argue Hicks stands for the proposition of the appellee in this case, because Hicks basically was a case where there was no properly perfected security interest, one. Two, it was never noted on the certificate. So here, if those questions were asked in Hicks, it'd be
there was a
no.
notice. In Hicks, there was a notice of a security interest, but it was never, that notice was never perfected. There never was an original title issued with the lien showing.
That's what I'm trying to say.
Right.
And in Hicks, the answers to the poignant questions there were no and no, where they would be yes and yes here in terms of what was actually noted, what it said on the certificate, and whether it was recorded. And all of that's public record. So I cannot see how there could be even an innocent purchaser type argument, whether counsel argues about knowledge or not.
So in other words, excuse me, go ahead.
Given your knowledge of the UCC and this case law, once a security interest is properly perfected, particularly a PMSI, what ways can that be lost? You've indicated it cannot be lost under the facts of this case.
Correct.
It cannot be extinguished, but are you aware of any ways in which that can be lost?
I believe I am, but that would be in cases where, for example, in the perfection of liens on goods, where one fails to renew them within the time prescribed under the Act, that would be a way. But in this case, where liens are perfected by filing and then noted on the title, the only way that is ever lost is by release.
So,
judicial order.
And in both those instances, that is either an affirmative act by the lender or a failure to act by the lender.
That is correct.
We have neither here.
Neither. And it's not even alleged that that is the case.
All right. Justice Breyer?
It sounded to me like what you had said in answer to your previous question was that no matter whether he's an innocent purchaser, the innocent purchase comes too late. That's the bottom line.
Absolutely.
That was the answer I was trying to get of your opponent earlier.
Thank you. I have nothing further, even though I have time, unless there are other questions of the court.
Do we have any further questions of counsel? Thank you, counsel.
Yes, sir.
We thank you both for your arguments this morning. The court will take this matter under advisement.